was dismissed by the High Court with costs, and it is against the order of the costs in which the GCB filed a counter-appeal. The GCB sought to prove that Jiba and Mqwebi were not fit and proper persons to remain admitted as advocates. The guidelines to be considered by a court before an advocate can be struck from the roll were stated in Yasat versus Natal Law Society 2000, Volume 3, SA 44, 2002, All SA 310 SCA. In Yasat, it was held that a court must firstly decide whether the alleged offending conduct has been established. Secondly, consider whether the person concerned in the discretion of the court is not a fit and proper person to continue to practice. Thirdly, inquire whether in all the circumstances the person in question is to be removed from the role, or whether an order of suspension from practice would suffice. The complaints against Jiba related to the Boyson's case and her handling of the spy tapes case. However, the main reason in the High Court's view was why Jiba was not a fit and proper person to remain on the role of advocate was her handling of the Mdluli case. Chongwe ADP, the majority judgment, considered the complaint against Jiba together with Jiba's answers and explanation in the context of her position as acting NDPP and the fact that Jiba was cited as a litigant. The majority judgment found no misconduct on the part of Jiba was established by the GCB. The complaints against Mqwebi were that he sought to mislead the court as to the extent of the consultation, or in inverted commas, in consultation between himself and Mzinyati. In that, Mqwebi took the decision to withdraw the fraud and corruption charges against Mdluli before he consulted with Mzinyati in terms of Section 24(3) of the NPA Act. And for this reason, he was not a fit and proper person. Mqwebi provided contradictory explanations of when and why he decided to withdraw the charges against Mdluli. The majority judgment found that, in respect of Mqwebi, the GCB established the alleged offending conduct. However, due to the fact that there was no personal gain from Mqwebi's conduct and the fact that the purpose of such proceedings are to uphold the rules regulating the profession and not to punish the wrongdoer, the sanction handed down by the High Court was not justified. The majority judgment further held that the High Court materially misdirected itself in striking Mqwebi from the role. It failed to consider why suspension was not an appropriate sanction. The majority judgment held that the appropriate sanction is for Mqwebi to be suspended as an advocate for a period of 6 months from the date of 15 September 2016. The counter-appeal against the order of costs arose from the complaint against Mzinyati. The complaint was in respect of certain negative remarks made against Mzinyati by Murphy J. In that, Mzinyati's confirmatory affidavit differed from the evidence he tendered at the disciplinary hearing of Breitenbach. For this reason, the GCB interpreted this contradiction as misconduct, and therefore Mzinyati was not a fit and proper person. The High Court dismissed the complaint against Mzinyati with costs. The GCB appealed the court's order. The majority judgment could find no reason showing that the High Court did not exercise its discretion honestly and judiciously, and for this reason it could not interfere with the findings of the High Court. Even though the GCB acted as custos muram, such cannot protect it from a cost order, especially when the GCB should have at least withdrawn the application to strike Mzinyati's name from the role of advocate. The Constitution provides that everyone is equal before the law and has the right to equal protection and benefit of the law. The counter-appeal was dismissed on these grounds. In a dissenting judgment written by Van der Merwe, J.A. with Leach, J.A. concurring, Van der Merwe, J.A. would have found that the appeals of Jiba and Mqwebi should fail and the cross-appeal of the GCB should succeed. I therefore read the following order. 1. The appeal is upheld with no order as to cost. 2. The counter appeal is dismissed with costs, including the costs of 2 counsel. 3, paragraph 177.1 of the order of the court, a co is confirmed. 4, paragraph 177.2.1 and 177.2.2 are set aside and replaced with the following, and I quote, the application for the striking of the role of Ms. Jiba and Ms. Mqwebi is dismissed with no order as to cause. However, as regards Mr. Mqwebi, he is suspended as an advocate for a period of 6 months from the date of this order, 15 September 2016. I hand down the judgment. Thank you. That's all. Court agents.
There you have it there, Judge Connie Mujumi saying that Jiba and Mqwebi can continue to practice, essentially.
Yeah, the Nomgcobo Jiba and Lawrence Mqwebi, she was saying that the appeal is upheld, the counter appeal is dismissed. We'll get more on that judgment as it comes. Remember the context of this, the Supreme Court of Appeal in Bloemfontein handed down judgment following the 2016 Pretoria High Court order that declared the two unfit to practice as advocates. So that was the judgment.
We'll continue to unpack that story as we continue with the program.